Shall we start, ma'am?
Yes, sir.
Yes, thank you, ma'am. So, good afternoon to one and all present here. It gives me immense pleasure to welcome you all to this FDP on intellectual property rights in academia. On behalf of the management and academic staff college, I extend a warm welcome to our respected resource person and faculty participants. In today's rapidly evolving knowledge-driven world, the role of intellectual property rights has become increasingly significant, particularly in academic and research environment. So universities and research institutions are not only centers of learning, but also hubs of innovation and creativity. Everyday faculty members and researchers generate new knowledge, technology, publication, and creative works. Protecting these innovations through appropriate intellectual property mechanism is essential to ensure that the creators receive recognition and their works contribute meaningful to society. So IPR commonly play a vital role in safeguarding inventions, research outcomes, designs, literary works, and technological invention. In academic, awareness about patent, copyrights, trademark, and other forms of intellectual property rights helps researchers understand how to protect and commercialize their work responsibly. It also promotes the ethical research practice and encourage innovations. This FDP has been organized with the objective of enhancing awareness and understanding of intellectual property among faculty members and researchers. Through the insightful sessions by our esteemed experts, participants will gain valuable knowledge on patent, filing procedure, copyright, protection, technology transfer, and the legal and ethical dimension of intellectual property in research. I also take this opportunity to thank our Honorable President, Sir, Dr. Malini Pandey, ma'am, Director, Academic Staff College, Dr. Gomadi, ma'am, Dean, Academic Staff College, for their constant motivation and supporting in organizing this program. I am confident that this FDP will serve us on excellent platform for learning, discussion, and exchange of ideas. The knowledge gained during this program will empower faculty members to protect the research outcome and guide students towards responsible invention. Once again, I extend a warm welcome to all. Let's start with the short introduction about our speaker. It is my distinct pleasure to introduce our esteemed speaker for today's faculty development program on intellectual property rights in academic. Dr. R. Krishna Kumari is a highly accomplished academic and researcher, currently serving as an assistant professor at the SRM Institute of Science and Technology. With a PhD in mathematics, her expertise lies in the realms of formal language, automate theory, and machine learning, making her a leading voice in the intersection of technology and education. Ma'am has been actively involved in various initiatives aimed at enhancing research output and innovation within academic institution. Ma'am has served as a resource person for numerous workshops and seminars focusing on the critical role of intellectual property rights in creativity and protecting the innovation in academic. Ma'am contributions extend beyond the classroom as she has coordinated webinars and workshops that bridge the gap between theoretical knowledge and practical application in the field of IPR. In addition to her academic achievement, ma'am has been recognized with several awards for her research, including the Best Paper Award at the International Conference on Information Technology Enabler for Persons with Disability. Her extensive publication record and active participation in professional societies underscore her commitment to advancing knowledge and fostering the collaborations among scholars. Today, ma'am will share her insight on the importance of intellectual property rights in research, equipping us with the knowledge and tools necessary to navigate this complex landscape. Without further delay, I over to you, ma'am. Thank you.
Thank you, sir. Shall I share the screen?
Yes, ma'am.
Yeah, is my screen visible?
Yes, ma'am. Yes,
Yes, ma'am.
Yeah. Yeah, am I visible? I hope so.
Yes, ma'am. You're audible.
Yeah, just a minute. Yeah. Am I visible, sir? Sir, am I visible?
Yes,
Am I
ma'am.
audible?
Yes, ma'am. Yes, ma'am. You are visible and audible.
Yeah, thank you. So, good afternoon to all the respective participants. So, first of all, I would like to thank the management of Dr. MGR Educational and Research Institute and also the respective coordinators of this program for coordinating such a wonderful faculty development program for intellectual property rights in academia. So, I just saw the list of all the resource persons. So, they are eminent personalities who indulge themselves much in IPR more than me. So since mine is going to be an introductory session, I just want to introduce more about patents, the basics about patents, so that it will be very useful for the participants to learn more things in the upcoming sessions. So I will give a broad, wide idea about what is meant by patenting, what are the basics of patents, and whatever that can be covered in today's session. Yeah. So here I have given a roadmap for today's session, and also this acts as a consolidated summary of the entire FDP. So as you can see, this session is structured into 6 interconnected sessions. So each section builds on basics to strategies about patents and aligns it towards practical application in academic research. So first we begin with section 1, that is patent basics. So where we will be briefly visiting the fundamental concepts. This is only to ensure that everyone is on the same page. And in section 2, we focus on why patents actually matters. So patents actually matters especially in academic ecosystem because linking patents to research actually impacts ranking, funding as well as innovation. And in section 3, I will be addressing about the patentability and section 3K, which plays a vital role in patenting. And it is also very important for mathematicians and also for researchers who are working with algorithms and software related ideas. So we will be dealing along with it in section 3. And in section 4 and 5, we will be focusing on strategies and best practices that will help to translate theory into actionable insights. And finally, in section 6, I will provide some practical tips and recommended tools that will be actually very useful for us to learn more about patenting. And this will also be just useful, not about just understanding, but it will also give us a clear next step what you can apply in our own research. So this is going to be today's framework for today's session. So let us go to the session. Yes. So in the context of academic and research work, intellectual property actually generally falls into 3 major categories, patents, copyrights, and trademarks. So first we should know the difference between what is meant by patents, what and all we should get for copyrights, and what and all it is we can get for trademarks. So each of these actually protect different types of intellectual outputs, and understanding this distinction helps us to decide what kind of protection is actually appropriate for it, for our work. Because generally we have an intuition that if we want to protect our work, we should patent our work. It is not so. Each of us are indulging in different kinds of works, and each kind of work involves different types of protection. So certain type of works actually involves copyrights, certain type of works actually involves trademark, and certain types of works actually involves patenting. So what is patents? So patents are actually meant to protect inventions and technical innovations. So that is like solutions that addresses some technical problems through some product or through some process or system. Those kind of inventions can be patented. While copyrights actually safeguards creative and scholarly expressions. So such as books, research articles, teaching materials, and even some software tools that are in the written form, we can get copyright for it. So most of our academic applications actually involve only copyright, not patenting. So whenever we are involved in some academic applications, we think that we should patent it before publishing it. No, all kinds of work can't be patented. So certain kinds of our academic work actually it involves only copyright. And then trademark is something that protects the brand identifiers. So brand identifiers in the same I have shown here. It is going to be like names, logos, and symbols, which become important when research leads to startups, products, or institutional branding. So these are going to be the 3 types of protecting tools that we are involving in our research work, and we should know the difference between them. So in simple terms, I can just telling that when we are going to write and publish something, copyright actually applies in it. And we are going to invent and solve some new technical problems, patent actually applying that. And we are going to commercialize and brand our product, trademarks actually apply. So this is going to be the difference between trademark, copyright, and patenting. So for today's session, we are primarily focused on patenting because patent plays a vital role when compared to trademark and copyright. So we are going to see what kind of things, what kind of our work can be patented. So, and also this patents actually forms as a bridge between research, innovation, and real world applications. So we will see what kind of work and all can be patented that involves in our research technologies. Yeah, so this will be a brief refresher to align everyone on core concepts before we move into patentability in applications later on the upcoming sessions. So we should know about the basic core concepts that should be patented. So what is actually a patent? A patent is nothing but it is actually a statutory right which is granted by the government to an inventor in exchange of some publicly disclosing that invention. So to qualify, this invention must actually satisfy three key criteria. So I'll be keep on repeating these three criteria because we should give importance to these three criteria while we are involving in patents. So first of all, our invention should be novel. It should not be very obvious. Something that is obvious, something that is already applicable in the real world applications can't be patented. And also our patent should be useful. Something that we are going to patent, we are thinking of patenting that doesn't have a practical usage cannot be patented. So always whatever invention we are involving with, it should be novel, non-obvious and useful. And also what the patent actually provides is not the right to practice the invention but the right to exclude others. So if we think that we got patent for our invention, that doesn't mean that we can practice, that is whatever invention we have made it, we can utilize it. It actually gives us a right that this is the product that I myself have created. So I'm owning rights for that and I cannot claim that my product is the best when compared to others. I can just claim that it is my invention and I'm the ownership of it. So that is the basic meaning of patent. Also, it also helps to prevent others from making, using, selling, or even importing the patented invention without permission. So nobody cannot use your invention without a proper governmental permission. So that is what the basic criteria of patent. So this protection is actually granted for a fixed period of 20 years from the filing date. So this is actually, this awareness is not among us. So if you are going to patent something, that doesn't mean that we are patenting for a lifelong process. Only for 20 years, we are having the rights on it. After 20 years, whatever we are thinking of upgrading in it, we should upgrade it and patent it again, or else we can also patent something other inventions that is based upon it. But only for 20 years, our patent that is filed is being given grant to us. And also for academicians, this system ensures that the research outputs with practical applications can be legally protected while still contributing to the public knowledge. So this is really essential for the academicians. So we should always remember after the filing date, the patent is only valid for 20 years. Yes. So what a patent actually protects? Patent actually protects technical innovations and not just abstract ideas. So abstract ideas in the sense, we as some theoretical ideas, if you're going to have something as a theoretical ideas, even like a software or some algorithms or some programs, whatever it, we cannot patent it. So the patent should be an invention that involves some technical knowledge as well as some technical aspects. Without any technical aspects, we cannot patent it. So this actually includes some new processes or some systems or missions or even technical solutions that actually involves a real world problem. So even improvements to the existing system can be patented provided they demonstrate a technical advancement. So for example, I'll just tell you with an example. Right now there is a walking stick for blind people, right? So these walking stick has many technological inventions in it, many technological advancement in it, such that the walking stick can recognize the heartbeat, the walking stick can recognize the pressure level, oxygen level, everything for an old age people. Similarly, there is also a blind stick for the blind people. So right now, if one stick is available both for blind people as well as for old people with all the technological advancement in a single stick with optimum cost, then it is going to be a new invention and we can patent it. So here we have used some old source of knowledge. We have made it, we have injected them into a single knowledge and we have also applied some new knowledge to it to make it as a patentable new invention. So this is going to be an example for this. And similarly, in the context of software and mathematics, protection is possible only when the invention is tied to some technical effect or some hardware implementation. So we mathematicians and many mathematicians find it difficult to patent their things because most of their inventions are based only upon solutions and it is only based upon mathematical results. So as a mathematical results or as a software result, we cannot patent it. So whenever our mathematical results and our software is implied to some technical product, we can patent it. On the other hand, we should also remember that patents do not protect any ideas or any theories or any discoveries or equations, whatever, as a mathematics in isolation. So we cannot patent it. So a mathematical formula by itself is not patentable. But however, when this formula is embedded into some technical system or to some industrial application, it may become patent eligible. So this distinction is actually crucial for academicians, and our goal is actually to move from theory to technical application so that we can make our invention much more applicable for patents than copyright. Because our mathematicians, since we involve only equations and theories, we can just make it as a copyright, right? Even for software engineers as well as for computer science department staff, your software, your algorithms cannot be patented without if it is not based upon some invention. We can just get it as copyright. So whenever our technical system is also embedded along with industrial application, we can make our invention more applicable for patenting. Yeah. So this slide actually highlights the core characteristics of patents that every academic should actually clearly understand. So patents are actually territorial rights. So this means that a patent is enforced only in the countries where it is filed and granted. So filing in India does not automatically give protection in other countries. So, and also patents are time limited. That is typically 20 years from the filing date. We have to pay the renewal fees in order to renew our patents. If you are not renewing it, then after 20 years, our patent will become elapsed. So that is elapsed in the sense after 20 years, our patent will enter into the public domain. So we should also remember this criteria. And the third thing is that patents operate on a disclosure for monopoly principle. That is, the inventor receives exclusive rights only by fully disclosing the invention to the public through the patent documents. So whenever we are going to fill all the patent documents, we should always disclose the full criteria about the invention. Then only we will be getting full rights for our invention. So this actually leads to the next point, that is full technical disclosure is actually mandatory. So the invention must be described clearly enough that even a skilled person can reproduce it. So this is actually necessary while filing our patent. And finally, the claims are the most critical part of the patent. So the claims actually, they define the legal boundary of protection. So what is claimed is said to be protected and what is not claimed is said to be free for others to use. So whenever you're going to produce an invention, you should tell whatever points, whatever criteria you're going to claim in that invention. So whatever you're missing out is not going to be patented under your name. So it is actually free for others to get it used. And also for academicians, understanding claims is very essential because by converting research into patents, we should properly give the claims of an invention, whatever we are going to claim. If not, then the remaining part will be apart from our legal boundary of protection. So we cannot claim that it is going to be my work. We cannot claim that it is under my patent because we didn't give the proper claim in our patenting. So this claim part plays a major role for researchers when they are going to convert their researchers into patenting. So this is going to be what our patent protects and what our patent does not protect. Yeah. So first, I was keep on telling about the main things of patents. So first, we should know the main terminologies about patenting, because these are the terminologies, but that will be keep on going through whenever we are going to talk about patents. Even in tomorrow's session or in the next sessions, they will be keep on using these patent terms. So we should be familiar with these terms, which are not the normal usage, such as a layman. We don't use these words as a normal in normal. So we should be clear about these important terminologies. An invention actually refers to a technical solution which is actually created by the inventor. So the person who is going to create the technical solution is called as an inventor, and the person who is creating the technical solution is called as an invention. And the applicant is the entity that files the patent. and the assignee is the one who actually finally owns the right. So there is always a confusion between who is an applicant, who is an assignee, and who is an inventor. So this is what the meaning is. The inventor is the one who creates the technical solution, and the applicant is the one who enters, that is who files the patent, and the assignees are the one for which the patent right. So if I'm going to file a patent along with my colleagues, then they will be the assignees and I will be the applicant. So all of us are owning rights for this invention. So all of us are owning rights for this patent. We come along together for this patent. So that is what is meant by applicant as well as assignee. And prior art actually represents the existing knowledge which claims actually define the scope of legal protection. So I said that while patenting, we should be properly giving what and all we are going to claim. So in order to what and all we are going to claim, we should be always doing a ground research about whatever it is already existing. So that is called as prior art. So whenever we are going to patent, there will be a point that tell more about the prior art. So we should know more about whatever is existing about the invention that we have made now, already existing knowledge. That is a previous knowledge, some known factors that is existing. So we should be clear about that. And claims, as I said, it is going to be a legal protection, and a specification is going to be the detailed technical document supporting the claims. So whenever we are going to see a patent, whenever we are going to, from the application number, if you are going to serve the patent in IPR portal, we can see all the specifications. There is a tab called specifications, and in that all the points, all the specifications of that invention will be mentioned. So from that we will be known that what the product is actually meaning about and what and all they are claiming about. So these are going to be the important patent terminologies that we should be aware of before patenting our research ideas. So types of patents. So patents are actually broadly classified into three global categories: utility patents, design patents, plant patents. So most of us are not aware of what is said to be utility patents and what are called as design patents and what are plant patents. Utility patents is actually forms the majority because it protects the technical inventions such as processors, machines, some software enabled systems, and also some mathematical models if it is going to be embedded in some practical applications. So these are said as utility patents. That is, we are going to patent our invention that can be practically used. That is why it is called as utility patents. And design patents are ones that protects only the visual appearance or aesthetics of a product, not its functionality. For example, if I'm going to patent a pen, if I'm going to get a design patent of a pen, if I'm going to give a new design to it, I'll just be patenting only the design. That design doesn't mean that my pen is going to be much more useful. It is going to be much more better than other already prevailing pens, right? I'm just going to give a new design to a pen and I'm going to patent it. So that is going to be a design patent. Whenever I'm talking about the tip of the ball of that pen, the ink of the pen, the refill of the pen, the sleekness of the pen, and the usage of the pen, then it will come under utility patent. So that is going to be the difference between utility patent and design patent. And plant patents are specific to new plant varieties. Plant varieties in the sense, most of our mechanical engineers and they are producing new plants, right? So that is going to be a big task, and we as a normal researchers, we always involve in utility patents and design patents. And plant patents in turn, obviously it gives only practical usage, and it is actually a big task that involves a institution level production. Yes. So the types of patent applications, especially in India. So in India, patent filing can be approached in different ways depending on how ready the invention is and what the strategy the inventor wants to follow. Provisional application is often actually the first step. So it actually helps to secure an early filing date, and it is valid for 12 months. So whenever we are going to apply provisionally, our application, that is our filing date, is actually valid for 12 months. So this gives the researchers time to refine their work. So we can file it, we can refine our work for 1 year, at most for 1 year, and we can also submit it again. So at this stage, detailed claims are not required. So most of our, if you are going to be in the initial stage of patenting, we can go for provisional application because it is going to be an initial simple step and it involves only an early stage of filing, and you can also redefine your work for 1 year, that is up to 12 months. And then when we go into complete specification, it actually contains the full technical details along with all the claims that you are going to give for your invention, and it must be filed within that 12 months if a provisional application has been submitted. So first, initially, if you're going to submit a provisional application, you will be given 12 months to make your work in depth, to work it in depth, and then you have to give the complete specification and you have to refile it along with all the claims. So that will make your application a proper fulfilled application. If an invention has already been filed in another country, that is not, if you're going to file an invention in India, but it is already filed in another country such as US or Canada, something like that, then a convention application can be used to claim priority from the earlier foreign filing. So that is called a convention application. So whenever, for example, if you have already filed some invention in US patent or in a Canada patent office and you also want to claim it in India, means then you can make use of this convention application. So that is going to be the difference between professional application, a normal application, and convention application. And for those who are looking at wider protection, the PCT route. PCT route, in the sense, it is called as Patent Cooperation Treaty. Okay, so this PCT route is a convenient option. So in simple terms, it allows an inventor to file one single international application and keep the possibility of patent protection for about 150 plus countries. But this is actually of high cost, and it also has some country specific decisions and later stage. But if you are patenting some bigger invention and you just wanted to get patented in among all the surrounding countries, then you can go for this PCT application. So although it is of more cost, it is much more efficient for bigger inventions. So these are some main types of patent applications that are already prevailing in India as well as in our foreign countries, and we can make use of these different types of countries whenever we are going to involve in patenting our invention. So generally, as academicians, we always involve in a provisional application in the initial stage, because after filing, from that filing period, we get 1 year to redefine our work and 1 year to redefine the claim, so which gives us much more time to rework on our research work. So obviously, we always go to provisional application, and after giving the complete specification, we go for a proper filing application and we then patent our work. So to understand patentability, 3 core criteria must always be satisfied. So as I said before, I already said these 3 core criteria. So first is going to be novelty. Novelty in the sense, the invention must be new and not disclosed anywhere in the world. And second is going to be the inventive step, that is non-obviousness, that is I already said. So the solution should not be very an obvious extension of some existing knowledge to a skilled person, not to a layman, to a skilled person. For example, if I'm just going to design patent a pen, means it should, just by showing the pen cap as a bulging one, it is not going to be a best design, because a skilled person will know that pen cap is of no use. Only the pen is going to be of no use. We are going to remove the cap and write it, right? So obviously, it should be non-obvious, and the inventive step should be something that is going to be much useful for making the already prevailing one as less usage. So you're going to make the new one should be more useful than the already prevailing one. And the third one is that industrial applicability is very important. If you're going to patent something and it doesn't have a practical usage, that is an industrial usage, means then it can't be published. After filing, they will give you some points that since it lacks these points, since these claims are not proper, it can't be published. Therefore, third is going to be the industrial applicability. That is, it should have some real world usage. It should be more practical for using. So all these 3 core criteria play a vital role. And for mathematicians, patentable outcome often arise whenever mathematical work is embedded in a technical system. So as a software engineer or as a computer science staff or as a mathematician, we should always involve our work into some technical system. At the same time, Indian Patent Act actually clearly specifies exclusions under Section 3. So we should be aware of this Section 3, in particular Section 3K. So this Section 3K actually tells that mathematical methods, algorithms, and also computer programs cannot be patented by itself. That is what is mentioned as section 3K is mathematical methods, algorithms, computer program per se. Per se in the sense per itself, that is by itself. It cannot be patented by itself. If you are going to make use of some mathematical methods, if your work involves algorithm, if your work involves some much more technology involved computer programs also, whenever it is going to have some practical usage or whenever it is going to have some industrial usage, then only you can patent it, or else you cannot patent it. You can only get a copyright for it. So if you're involving in just a modeling methods or algorithms, you can get copyright for it, but you cannot patent it. Whenever it is going to have a practical usage only, you can patent it. Therefore, the key takeaway for these kind of faculty is simple, that these theoretical subjects by itself cannot be patented, but these theoretical subjects, whenever it is combined with some technical application, it can be patented. Yeah. So a patent document is actually, it is structured somewhat like a research paper, but with some clear legal purpose, right? So as a researchers, we know what are the chronological steps to write a research paper, right? So forming a patent document is also like a research paper. You should follow the proper steps in a hierarchical order so that we can make our patent filing move on to the next stage, that is for a publication as well as for getting grant, right? So that's why I just mentioned this as anatomy of a patent documentation. So this actually begins with a title and a field of the invention, and it is followed by the background. So which actually points out the gaps or limitations in the existing work. So whenever we are going to make a background study, that is whenever we are going to make a survey, literature survey, we will obviously get the limitations of this invention as well as the gaps in our work. So the limitations and gaps should be mentioned while filing our patent. And this is then supported by the objectives of the invention. So the objective of our invention should be properly specified point wise, which will only lead us to the next step, that is which will only lead us to the publication part. So these are going to be the first 3 steps which is essential whenever we are going to document our patent work. Then the summary actually gives a quick overview of the idea, and while the detailed description, it actually explains how the invention actually works, often with the help of drawings. So the most critical part is that claims, as they clearly define the legal boundaries of the production. So we should always give more importance to the claims. So if you are not giving much more importance to the claims, then you are not giving the proper boundary to your work. So if you are not going to give a proper boundary, and if somebody else is going to give that the clients that have left out, then that is going to be their work and that is going to be much more innovative than yours. So your work will become much less, so it can't be patented. So giving the proper clients for your invention plays a major role in it. And finally, the abstract, it provides a short technical snapshot mainly used for research and classification. So this structure is actually very important, and whenever we are going to write a work, that is whenever you're going to document your research work for patenting, this is going to be the anatomy of a patent document. First, you should give importance to the title, then to the field of invention, then you should give a proper background study, that is the gap and limitation that is involved in the existing work. Then you should give the detailed description of how this invention actually works. And then that is the most crucial part that plays a vital role, that is claims. You should give the proper claims, that is the proper boundaries of your work that should be protected. And finally, a short abstract that gives all the technical snapshot of whatever your invention involves and how it is going to be good for practical usage. So all these points should be there whenever you're going to document your work for patenting. So when a patent is granted, the inventor receives a set of powerful legal rights that goes well beyond publication, right? So these are going to be the legal rights that is actually a patentee will be receiving. The one who patented is called as patentee. So first is the right to exclude others. Right to exclude others means no one can make use or sell the invention without your permission. For example, as a mathematician, if a mathematician develops some graph-based optimization method that significantly reduces the computation times in areas like logistics or fraud detection, Others cannot commercially use this solution without your authorization. So that is called as right to exclude others. And the second is going to be the right to license the invention. Right to license the invention in the sense, this allows the patent holder to let others use the technology in return for royalties. So whenever we are going to receive royalties from others, you can give them the right to license your invention. For example, the same invention that I mentioned now can be licensed to multiple organizations such as banks or supply chain companies, while the invention or the institution actually retains the ownership, but you get the royalty for that. They get the royalty for that, you give them the royalty so they can make use of it, and it is going to be your work and you're going to have the right, but only the royalty you're giving to them. So that is called right to license. And third is going to be the right to sell or assign the patent. A right to sell or assign the patent in the sense, ownership can be transferred to a startup or to some industry partner or to some institution. So this is actually common in many universities. So whenever they are going to involve in some mathematical model, or whenever they are going to involve in some programs, it becomes a part of some commercial software or some AI driven system. So they give the right to sell or assign, because you right now you have heard of many new website creations, right? So many new type of website creations are being done by individual people, and they just sell it to some startups, or they just sell it to some institutions or industry partners. So this is like selling to them or like assigning the rights to them. So this is also a right that is guaranteed to patenting. So whenever you're going to work on it, while working itself, you can patent the work, and after completing it, you can even sell it, or else you can even assign it to some institution or some industry partner. Finally, the patentee has the right to enforce the patent by taking legal action against infringement. Infringement in the sense, if someone is making use of your patent work without your knowledge, you have the right to take legal action against them. And this action will be taken in a short period of time. So you have the full rights to do it, because you will be having all the necessary documents and it will be already available online. So you have the right to enforce legal action against the infringers. So together, these rights actually transform an academic idea into a legally protected and economically valuable asset. So I can say that this actually opens doors to many real world impact and commercialization. So we should always be aware of these important four rights whenever we are going to patent an invention. Yes. So here I have shown a complete end-to-end view of how a patent evolves from the birth of an idea to the end of its legal life. So this is going to be the entire patent life cycle. So first, the patent actually begins with ideation. Ideation in the sense, at this stage, the inventor actually identifies a problem and proposes a solution. For example, as a mathematician, this often starts like a model or an algorithm or some optimization technique. But it is important to already think in terms of technical applications. If it is just going to be a theory, obviously I can't go for a patenting. So at the beginning itself, whenever I'm going to get an idea based on some optimization technique or based on some model or based on some algorithm, then next I should extend my idea that how I can apply it technically. Rather than just being it as a theory, how I'm going to apply it technically. So this is going to be the first step of the patent life cycle. And next comes the prior art search. Prior art search in the sense, that is what I already mentioned as a literature survey. For papers, we just name it as literature survey. For patenting, it is called as prior art search. Prior art search in the sense, existing patents and publications should be reviewed to check whether the idea is truly novel. Because if that idea is already prevailing with just a simple difference, means then we cannot patent it. So we should obviously check with the existing patents and publications. This step actually helps us to refine the invention, and it also helps us to avoid duplication, and it also helps us to shape stronger claims, because claims play a major role. So this step also helps to stronger our claims. So whenever, if you are going to skip this step, 100% or 99%, our patent filing will get rejected. So prior art search plays a major role because if you're going to list out whatever prior art search we have done based upon publication and patenting, that will give a weightage to your work while filing. So they will move to the next step. If you're not going to give the proper prior art search in the documentation, then obviously at that stage itself, they will reject it. Then also the next one is going to be provisional filing. Provisional in the filing itself, already I said you, if the idea is still evolving and you're not complete with the idea and you just want to rework on it, you can make a provisional work. So this secures actually an early priority date without requiring full claims, because still you're working on it and it doesn't require full claims. This is especially useful in academia when research is ongoing or still research you just want to improve it. So whenever you're involving in some ongoing research and whenever you're going to involve in some research, if you want to improvise it, means then you can go for provisional filing. So this is going to be your third step. And if you are involved in provisional filing, you should remember you can just do your work only for 12 months. Within 12 months, the inventor, that is we as an inventor, must file the complete specification. If you are not going to file the complete specification, then in the third stage itself, it will get rejected. So whenever you are going to involve in provisional filing, within 12 months, you should give the complete specification. So this is going to be the most crucial step, because in complete specification, you should importantly give all the claims that you need for your patent. So this claim actually defines the legal scope of protection. So within this 12 months, you should be ready with all the complete specification. So right now, we have done ideation, prior art search, that is literature survey, and then provisional filing. Then for 12 months, you're going to give the complete specification with everything. You're ready in 1 year. So after being this, you will be giving a complete filing, because initially it was a provisional filing and now it became a complete filing. After a complete filing, this application moves to the next stage. The next stage is going to be a publication stage. This publication stage usually takes after 18 months, because 12 months is there for provisional filing itself. So after 12 months only you're going for complete filing. So this publication stage actually goes after 18 months. From this point, the invention becomes publicly visible and the provisional rights begin. So whenever your patent is published, it will be publicly available in open sources and the rights also begins for you. So filing patent, how filing patent is important. Similarly, publishing patent is also invented. Whenever your patent is published, so you can claim that, provisionally claim that that is going to be your invention. And the next step after publication, it will go for examination. So in that examination part, they will be checking those 3 core criteria. That is the novelty, whether the patented, that the filed and published work is novel or not, and whether this is going to be an inventive step or not, whether there is industrial applicability or not. And also they will be checking the compliance with section 3K. Section 3K in the sense I said mathematical models, equations, algorithms, programs, nothing can be patented by itself without any output, practical output. So they will be checking that compliance also. So that is essentially, and that part will be given as compliance with 3K. So this is going to be your next step. So whenever your patent is published, it will go for examination step, and that is going to be your 6th step. And whenever any objections are raised after this examination step, these objections will be raised through office actions and responses. So you will be getting this objections from office actions and responses. This back and forth with the examiner is actually normal, and it often determines whether the patent will be granted or not. So whenever they are going to raise some objections, and if you are going to have some solutions for it, you can again replace it. You can just tell them that these are going to be the solutions for the objections that you have raised. So again, it will be examined. And after examine, if they are going to have some doubts, means again they will be claiming some doubts in this office actions and responses, and you can respond them with your answers. So this is going to be like a cycle process, and whenever they are going to get satisfied with their responses, and whenever all these objections are successfully resolved, the patent will get granted. So this patent granted is going to be the final stage of patenting, right? So your patent will get granted, and now the invention has the full exclusive rights over the invention. So first is going to be patent filing. So patent filing first involves provisional filing, and after that complete filing. Complete filing involves complete specifications. After complete specifications, it involves examinations, and all these processes for 18 months. And examination may involve many months, because they can have many objections or they won't even have any objections. So after clearing all the objections, finally the patent will be granted. That granted patent can be an utility patent or design patent or plant patent. For whatever you have applied, that type of patent will be granted to you. So that is going to be the final stage. And if you want to keep the patent active, renewal fees should be paid periodically. If you don't pay the renewal fees, then obviously you will be losing the rights. So this renewal fees should be paid 20 years from filing. So after 20 years from filing, it will come to the public domain. So if you're going to renew it after 20 years also, you will be having the full rights for the invention. So this is going to be the entire patent life cycle that we should be aware of. Because whenever we are talking about patent, most of them are getting doubts about some say that it is patent published, some say that it is patent granted, and some are talking as design patents, some are talking as utility patents. What is going to be the difference between them in the sense? Utility, design, and plant patents are going to be types of patent, and this is going to be the life cycle of patent. So before getting a patent granted, obviously it would have reached the publication stage. After reaching that publication stage only, it would have followed examination, and then only it would have reached the grant stage. If the examiner is not having any objection, it will get granted in a short period of time. If the examiner is having any objections and if you are not able to clear it, then your patent will get stopped in publication stage itself and it won't go for grant stage. So this is going to be the entire life cycle of the patent. So yes, so this section briefly explains why patent actually matter. Matter in the sense not just legally, but also academically as well as commercially. So we will just see that. Yeah. So why patents are especially important for researchers and academicians? Because we in our universities are actually somewhat directly or indirectly forced to patent our works, right? So filing a patent actually helps to protect our innovations. So it is actually best practice for us. And also before publishing it in a journal, it ensures that the novelty is not lost. And always we should remember, I think from 2023, we should always patent our work before publishing. After publishing, we cannot patent our work. I think till last year, we can patent our work for 1 year after publishing, but right now we cannot patent our research work. If you have published means then we cannot patent it. So whenever you're involving in some research work and whenever you're sure that you're going to get some fruitful results, your innovation is going to be novel, patenting is going to be the best solution for it. So that's why we are always forced in our academic institutions to patent our work before proceeding into some journal publications. We are asked to patent our work. And also patents add strong value to grant proposals because they clearly demonstrate practical relevance and real world impact. Real world impact in the sense funding agencies increasingly look for real world impact, right? So funding agencies always want work that can be applied practically, that have some industrial usage. So whenever you're going to patent some invention and whenever you're going to publish the invention that is patented by citing it, it gives you more prominence to get funds. And also patents helps, I have already said it will help to open doors to commercialization through licensing. Patents will help to get us consultancy projects and also patents will help us to get industry collaborations. So these are some things that actually turns research into usable technologies. That is what we are seeking for. So patents actually plays as a foundation for it. At the same time, patent also contributes to individual and institutional recognition, such as it helps for supporting metrics used in rankings such as NIRF and NAC. So most patents are actually, they prevail as a safeguard for ranking purposes because they safeguard the original ideas. They also help to prevent the misuse or plagiarism and ensure that the researchers receive due credit for their resources, for their innovations. So institutions actually help us, tell us and also provide us pathways to patent our innovations. So that's why we are always forced to care more about patents. Likewise, equally important to publications, we should also give more important to patents also. Yeah, so section 3K actually plays a major role because right now all of us are indulged in interdisciplinary work. Say as a biotechnologist or a physics or a chemist or a mathematician or a computer science, most of us are involved in interdisciplinary work and we just want our work to have applications. So whenever we are involved in some, since most of us are using AI and machine learning, most of us are involved in programs and software which cannot be patented. So if our work, that is our research work, involves some softwares or patents, some mathematical solutions, whatever it is, we cannot patent it directly because this section 3K plays a major role in it. So we will see about it. Yeah. So as I said, the three important patentability criteria we should remember, that is an invention, whether it is going to be a mathematical invention or otherwise, it must satisfy novelty, inventive steps, and industrial applicability. If it is going to be novel, if it is going to be non-obvious, and if it satisfies industrial applicability, obviously we can involve in the first step of patenting, that is filing the patent. And novelty means the idea must be genuinely new and not disclosed anywhere in the world. Not disclosed anywhere in the world means even a conference paper or a preprint can destroy novelty, because now many of us are involved in preprints, like we are just posting our papers in Aziz, we are posting our papers in research square, research circles before it gets accepted, right? Before our paper gets accepted in journals, we are posting in it in order to make it widely available to the audience. If you're going to make that, those kind of work can't be patented, because it now right now we have disclosed this everywhere. So obviously novelty doesn't play a role here. So those kinds of work can't be patented. So if you want to patent your work before it gets published, then please don't involve putting your papers in any open sources like Arzivs or research cycles or research quiz, whatever it is. Please don't put your papers in it. And also inventive step requires that the invention should be not obvious to any skilled person, also a layman in that field, and it must also represent some real technical advance. Real technical advance in the sense it must have some practical usage. And now this is where section 3K actually becomes very critical for mathematicians as well as for computer science staff. Because whenever a computer science or a mathematician invention satisfies this novelty and inventive step, it can still be rejected if it is viewed as a mathematical method, if it is viewed as an algorithm, or if it is just viewed as a computer program, right? So pure equations or some abstract algorithms or some theoretical models, no matter how elegant, they cannot be patented. They are always excluded. So this law actually doesn't reject mathematical itself. It rejects the mathematics without technical applications. So patent means there should be a technical application. If there is not a technical application, filing a patent or involving in publishing a patent doesn't going to give you any fruitful results. Obviously, in the stage of examination, it will get rejected. If it is going to get rejected and if you are not going to get grant, mean that there is no use of involving in all these steps. So whenever you are having some innovative results, obviously you should go to the next step. You should check whether technically it has application or not, or how to involve your innovative results technically, how to merge them with some technical application. Whenever you're going to merge your models or merge your programs or algorithms to some technical application, obviously you can go for patent filing. So in the sense, any ideas, theoretical ideas, if it is going to embedded in some systems, or if it is going to interact with some hardware, or if it is going to measure some technical effects such as improved speed, accuracy, or security, or some efficiency means, then obviously it is going to be some technical advancement. So you can file those kinds of patents. For example, I can tell that some new optimization formula, it cannot be patentable. But whenever it demonstrably reduces the computation time in some scheduling system, or it improves the accuracy of that system in some machine learning pipeline, then that it is going to be a technical solution and you can involve in patenting it. So just by disclosing a new mathematical formula, obviously you cannot patent it. Just by disclosing a new program, you cannot patent it. You should tell that how this program, when embedded in some hardware system or embedded in some technical system, it is going to improve the speed of the system or accuracy of the result, or whatever the result, it is going to improve the result means, then that kind of work can be patented. So always we should ensure that our work meets these three criteria, and then we should frame it as a technical solution, and it should not just be a standalone algorithm, because if it is going to be a standalone algorithm, then filing a patent and waiting for 12 months with our provisional application is not going to help us. It will get rejected. So this is the place where section 3K plays a role. So section 3K, in short, we can just mention that it actually simply specifies the boundaries. It actually helps us what and all should be claimed and what and all should not be claimed, and what and all will go to the next stage of patent filing. So this is going to be the major role of section 3K. Yes. So turning theoretical research into a patentable invention really requires a change in the mindset, right? So right from thinking in abstract terms to thinking about real problems and real solutions, the starting point is to clearly identify the practical problem that actually the research addresses, such as the practical problems such as inefficiency, delay or inaccuracy, or even some security issues. Rather than just focusing on only on the beauty of the theory, we should always focus on the practical problem that involves after forming the theory. And the next step is going to explain the practical advantage the theory actually offers. So whether it leads to some faster computation or some lower memory usage or some better accuracy or some improved stability, this helps us to establish the novelty and value of our work. So obviously practical advantages essential to turn theory into practical systems. And then this idea needs to be translated in a system view. So first we should have the mindset to identify a proper technical problem, and then we should know how to make it as a practical advantage. And the third step is going to be that it should be translated into a system view. System view in the sense representing the theory through some block diagrams or showing inputs, processing stages, decision points and outputs actually helps to demonstrate that it is more than just an abstract concept, and it helps in technical nature, right? So this is going to be the next step to turn the theory into some practical systems. And then you should add some measurable results. Measurable results actually makes the invention much stronger. So some concrete improvements are such as if you're going to reduce the execution time, if you're going to reduce the error rate, or if you're going to save the energy, then obviously it is going to be a measurable result. This comes under measurable results. So this also plays a major role to make your invention much more novel. And finally, showing that how the idea can be implemented through some hardware interaction or through some simulations or some prototypes. As I mentioned in the starting, some prototypes means it obviously confirms the real world applicability. So this stage, subjects like mathematics or computer science actually becomes the engines behind a working system. So since it becomes the engines, the models, the programs, everything becomes the engines behind the working system, it makes it suitable for patent protection. So rather than just purely remaining as a theoretical, we can also claim to patent our work, because here our mathematical work, here our programs, here our algorithms plays a major role as the product of that technical system. Therefore, this idea can be implemented. Yeah, so strategies and best practices. So yes. So yes, so strategies and best practices in the sense, there are few important strategies that is involved while patenting. So let us see one by one. So protecting our intellectual work before putting into public domain is extremely important. Why it is extremely important in the sense, once an idea is disclosed, we cannot take it back. So we cannot take it back. Also, filing a provisional patent at the right time actually helps to secure the novelty of the work, because you're just involving in a provisional patent. But after involving in a provisional filing, please don't put anything in a public domain, because you may think that I have provisionally filed it, so now I have the rights to put it in the public domain, so that won't help it. So if you are going to do that, then obviously your work will not reach the next stage. You cannot go for a full filing stage, right? You cannot go for the full specification stage. So this will help to lose the confidence to publish later. So please don't go to any public domain. So that is going to be the first strategy. And when it comes to patenting in subjects like theoretical subjects like mathematics or computer science, some soft IT subjects, collaborations play a major role. For example, if I'm having some mathematical results to involve in some missions. For example, some DNA testing missions means I can just apply for a design patent. So that biotechnologist, he will be making a DNA testing device. He will be giving the design of that, and I can specify the specifications for that, and all together I can apply for a design patent, and it will be getting granted. So obviously, collaboration plays a very important role in it. So many theoretical ideas are actually very powerful in theory, but they come true alive only when we work together with the experts such as mechanical engineers or electronics or AI, ML, and also with industry partners. So such collaborations actually helps to transform these abstract concepts into practical implementations, leading to good solutions, right? So obviously collaborations plays a major role. So that is going to be a one good strategy for patenting our work. And yeah, so the next strategy is that we have to document everything. So document everything in the sense of careful documentation may not be always visible, but it is one of the quiet strengths of successful patenting. Keeping a proper records such as drafts, data sets, code versions, and even relevant email communication helps to clearly establish who contributed what and how the idea evolved over time, and also it helps the technical clarity behind the invention. So this is also a good strategy whenever you're going to involve in filing a patent. And also it is equally important is seeking guidance early. Seeking guidance early in the sense you have to consult the institution's IPR cell. So we institutions, all of our institutions is having an IPR cell, right? So whenever we are going to consult them, we can also consult technology transfer office, or we can also consult some patent attorney. There are many patent attorney available. So at the right stage, if you are going to consult them, this will make a significant difference in filing our patent. So always we should remember that early discussions helps to frame the claims correctly, because framing the claims correctly, obviously next stage it's going to lead to protecting your work properly. So since these people are much more involved in those kind of work, whenever you're going to indulge in some proper invention, you should always document your invention. You should always have proper documents, all the details about the invention, and if you're going to approach them, they will help you with the proper climbing ones, whatever you should climb in order to make your product much more protective. And this will also help to prevent mistakes that can become much more expensive, or it can also become some irreversible later, because whenever involved in your patent journey, that examination step plays a vital role. If you are going to raise some objections, and if they are not satisfied with your responses means, then obviously we are not going for the grant stage, right? So this will become an irreversible problem in the later stage. So obviously initially itself, if you are going to consult the IPR cell means, it will be very useful for filing our patent in a correct, proper format. Yeah, and this is going to be the last strategy. So a patent's real strength lies in claims. I have already said this many times. So they should be, claims should be actually broad enough to cover variations, yet precise and defensible. So clear technical boundaries and multiple embodiments actually protect the invention from easy workarounds. Easy workarounds in the sense we should draft the claims, and even with a good invention with a not proper claims can make a patent practically unenforceable. So claims plays a major role. So if you think that your invention is very good, and if you're not sure with what and all claims you should give for that, please contact the IPR cell of the university. They will help with your claims because they are well used to it. But before going into that stage, you should be thorough with the prior art search, because prior art search will help them what and all to claim for your current work. If you have not done the prior art search properly, your current work claims can't be done effectively. So that will that will make your patent practically unenforceable. Therefore, always first go to prior art search, and then we have a clear technical boundaries of what and all you should claim and what and all you should not claim. And if you are not clear with those boundaries, please contact your institution's IPSL, and they will tell you what and all type of claims you can give for your invention. So these are going to be the 5 major strategies that is involved before filing a patent. So if you're clear with these strategies, you can file your invention and you can be sure that it will go to the next stage. If you're not clear with these strategies, obviously any other in between stage you will be having an hindrance and it won't go to the next stage and it will be like a backlash. Yeah. So section 5 is going to be some practical steps for converting research ideas to patentable inventions, because most of us will be having research ideas but we don't know how to patent it, right? So we can see some practical tips in it. So always yeah, so always before filing a patent, first run through the checklist. Run through the checklist in the sense, first be clear about the real problem your idea solves. It should not be just a mathematics or it should not be just a program behind it. What is going to be the real problem? What is your idea? What it is going to solve? That is going to be the first step. And the second step is that we should confirm the novelty through at least a basic prior art sketch. So you cannot still just claim that I just viewed for the past 3 years and I found out that nobody has done a research work like this, so my work is not novel. You should not claim like that. First, you should make a fundamental prior art sketch. From that, you should make an in-depth prior art sketch. Then only you can claim that your work is novel. Before confirming that your work is novel, you should be thorough with literature survey. And also you should ensure that the solution delivers some measurable technical advantage. If it is not going to give some measurable technical advantage in the sense it should be increasing the accuracy, it should be increasing the efficiency of the system, or it should make the it should make more cost efficient. If it is going to make like that means, then obviously it is having some advantage. If it is not having technical advantage means, then you cannot tell that your invention is going to be novel and non-obvious. And also you should clearly go beyond section 3 exclusions. If your invention involves only section 3 means, obviously it will be excluded in the filing stage itself. So this is going to be the checklist before filing. And then your system should be implementable. Implementable in the sense it should be supported by some block diagrams that show how the components interact in practice. Just don't give some theoretical abstract. You should support your the system that it is involved in your invention. You should just show it using some by block diagrams that this is going to be my first stage, and after passing these stage, my invention will come to this stage. At this stage, my invention shows that the product is going to be much more efficient and it has some technical uses, right? So you should involve some block diagrams in it. And equally important is avoiding some common mistakes. Common in mistakes in the sense, do not file pure some programs or some mathematical formulas without any technical concept. And also avoid filing without any real world evidence or experimental validation. You should just not say vaguely that this can be used here, this can be used there. You should give a proper real world evidence. If my product, after having these technical aspects, it is going to be practically, it can be used here and it will give me efficient output. If you are going to sure about that only, you should mention that in the filing stage as an objective, or else it will never get published. And also, as I said before, never publish it as a paper before filing. It will obviously destroy the first step, that is novelty. And also, weak claim drafting and skipping the prior art searches are the most common, biggest reasons a patent fails. So, if you're going to follow all these checklists, surely after filing your patent, it will reach the publication stage. So these are some recommended patent and IP tools I will be mentioning in this section. So these tools actually help with prior art search. It helps in patent drafting. It also helps in filing. It also helps in some IP management. So the tools that I'm going to mention in this section actually makes the patent process faster and clearer and more effective, because now this is an AI era. We can make use of AI in a proper usage, right? So there are many tools that helps us to make our work patent. So if you're going to make use of that, it will be easy for us to fulfill our checklist, to make our work patentable, right? So I will just mention all these tools. You can make a note of it. Yeah, so these are some commonly used patent search and prior art databases that are widely listed. So before filing a patent, it is essential to check whether similar ideas are already existing, right? So USPTO patent search actually provides access to US patents, and it is often the first stop for global prior art checklist, right? So whenever you're going to involve in literature survey, if you're just going to search in this portal, you can just make use of the prior art checks globally. And also eSpaceNet, it is maintained by European Patent Office, and it actually offers access across over 100 million patent documents across the countries. So eSpaceNet is also much useful before filing a patent. And for country-specific searches, you can just make use of JPlatPack. It is very useful for Japanese patents, and as well as CNIPA. It is particularly important for emerging technologies like machine learning and AI. And in Indian contents, we just know that IP India's InPass and public patent search portals are officially available, and you can verify the published and granted patents there itself. So by making use of all these kinds of multiple databases, we can ensure that our work is novel. So this is going to be like a novelty check database. So this obviously reduces the risk of rejection during examinations, because after filing you will be waiting for 12 months for full-fledged application, and after publication after 18 months you will be waiting for examination. In the examination, if your filed patent is going to get failed in novelty means, then that shows that you haven't made prior art search globally. So in order to make your prior art search globally, you can make use of these open source tools. So these tools are widely available, and many patents are widely available in these databases, so you can make use of that. Yeah, so these tools are used after identifying relevant patents to access their quality. So initially, I just mentioned certain tools that are very helpful before filing the patent, that are helpful for prior art search. So those are those kind of tools, and these tools are actually after identifying the patents, you can also access their quality, you can access their impact, their strategic value, whatever it is. So Derwent intervention. So this is actually supports detailed citation mapping, and it also helps high quality patent analytics. So this is also open source, and you can make use of it. And patent site focuses on evaluating patent strength valuation and portfolio performance. And Innography enables technology landscape analysis and competitive intelligence. That is, it helps to identify the emerging domains, and it also helps to identify the white spaces in between, that is the gaps in between the prevailing ones. And iPlytics is especially useful for analyzing standard essential patents, and it actually tracks a long-term technology trends. So it is much more useful than the remaining ones. So these are some valuable analytics tools. It helps for guiding research planning. It also helps for guiding patent filing. It also helps for technology commercialization decisions. So you can make use of these tools. Yeah. So today, as I said, AI tools are widely used in patent analysis and drafting. So tools like PatentPal, it actually helps in structuring patents drafted faster. So PatentPal is widely used, and Ipsum AI also supports claim analysis. I think Ipsum AI is not fully accessible, but it is accessible in universities up to a certain extent. So it actually supports claim analysis, and Amplified.ai assists with patent research and competitive intelligence. And Deep IP helps in technology landscaping and trend identification. So as I said, AI is not perfect. You can make use of these tools. So, but these tools can sometimes miss legal nuances, and you can also experience that an experienced patent professional would immediately notice. So this will be very useful in the initial stage. But after making use of these tools, you should always have a legal opinion with the patent professional, because they will immediately notice the mistake that these tools have done. And also in some cases that AI generated claims may sound correct, but it may sound too generic or not too strong enough legally. So you can have those claims basically, and you can also involve professionals to make that generic claims more specific, because if your claims is going to be generic, then you won't be getting patents. Patent claims should be much more specific. So, and also it should have some strong motivation to get patented. So you can make use of these AI tools for initial stage, and then later on you can contact a professional to strengthen your claims. And also another concern is that AI systems relies only on existing data, but since it relies on existing data, if you're going to create a document using AI means, then you cannot make yours as a novel one, right? And also if the data is incomplete or biased, the analysis also can be misleading, right? And also patent laws across varies across various countries, and the AI may not capture everything. So always have AI tools as a supporting tool. Don't involve and don't rely upon it entirely, because the results that you're getting from the AI tool, it is not going to be fully fruitful, but it will be helpful for you in the initial stage, because it is not going to be a replacement for human judgment. So you can make use of AI tools in the initial stage, and later on you should refine it, because it is going to be your work. You know the strength of your work. You know the specific criteria, the specific climbs that you should climb for your work. So by using it as the base one, as a skeleton, you should have a proper, significantly improve it from the basic AI work. And yes, so So these are some widely used patent drafting and IP management tools. So initially we saw tools that is useful for filing, and then tools that is useful for patent analytics. And these are some tools that are very useful for patent drafting and IP management. Anaqua is commonly used for end-to-end IP lifecycle management, and especially it is useful in large organizations where filings, deadlines, and renewals need to be tracked systematically, right? So since it is need to be tracked systematically, this Anaqua is commonly used. And PatSnap actually combines patent drafting support with analytics and portfolio management. So it actually makes it useful not only for filing, but it is also for strategic decision making. This PatSnap is very useful. And IP Folio focuses more on IP asset management and tracking. So this helps institutions and companies monitor their patents, cost, and also legal status efficiently. And the last is going to be CPA Global IP platform, which is typically used at the enterprise level. It offers a robust solution for managing large and complex IP portfolios across multiple jurisdictions. So these tools actually greatly improve the organization efficiency and compliance. But we should always remember that they just supporting the drafting and management process, and they do not replace the legal expertise. So you can just make use of these tools as some supporting tools, and you should not replace the legal expertise that those who are prevailing in our universities. For initial drafting, for initial filing stages, for initial analytical stages, you can make use of these tools, and you should refine it along with your human knowledge, with your human work, and then you should go to an professional to recheck it, and then only you should involve in filing in order to successfully get granted from it, right? So this slide actually focuses on research to patent mapping tools, which are especially useful for academicians who already publish research but may not yet be actively filing patents. So most of us are involved in research work. We are publishing papers, but we are not yet actively filing patent. So this is going to be tools that helps to convert your research work to patent. It helps as a map. It helps as a gap finder in between them. So the lens scholarly actually works, helps to map research papers directly to existing patents. It allows the researchers to see whether similar ideas have already been patented and how academic work translates into some protected inventions. So that is going to be the role of the lens scholarly. And the dimensions.ai, it has a wide usage. It is an open access, and it connects grants, publications, and patents on a single platform. So it can be much useful for prior art search, because it connects everything in a single platform. So it will also be useful for you to cite the previous work. So and it is also very useful for understanding how funded research progresses into some applied outcomes and intellectual property. So you can make use of this workplace for that. And also Scopus is there with patent links. Scopus is widely available with patent links that it enables identification of patents that cite academic publications. So this is a powerful way for researchers to realize that their published work may already be influenced patenting technologies. And also Web of Science, we know about Web of Science, and Web of Science is integrated with dormant data. This actually provides a strong research IP linkage. This helps to trace how some scholarly output evolved into some commercial or industrial innovations. So these tools are helpful for us to map research along with patenting documents, and everything is open access only, so you can make use of it. You can surf in the net and you can see. If you're going to just put a topic in it, you will be getting ample of documents in that, so you can make use of it. Right. So we have come to the end of the presentation. So at this stage, many researchers actually they ask a very practical question that are there are so many patent and there are so many IP tools available, but which one should I actually use and when should I use it? So this slide actually answers that question stage by stage. So if you have some early stage idea, so the idea is only at the early stage, means you make use of Google Patents. Google Patents is available and lens.org is available. So when you have an idea, maybe some research concept, a project proposal, or some student innovation, you don't need heavy analytical tools, because right now you are only in that idea on stage, right? So you don't need any heavy analytical tools. At this stage, the goal is only to understand. So have something similarly already been done or not. That is what is going to be this stage. So at this stage, Google Patent will be very useful because Google Patents are free and it is also keyword based. If you are just going to give a keyword, means it will give you all the details with respect to that keyword, and it is very easy to explore broad ideas. So for early stages, Google Patents can be used. Similarly, lens.org, it is specially useful for academicians because it connects the research papers and patents, and it also helps you to see whether the academic work is already influencing technology or not. So for early brainstorming and idea validation, these two tools are more than sufficient. So at early stages, you can make use of these two tools. And then for novelty check, whether to check your work is novel or not, KeyspaceNet and WIPO is much more useful. That is, once your idea becomes more concrete, and the next critical question is novelty. In patenting, novelty is not negotiable, right? So when your next critical question is novelty, you can make use of these two tools. So eSpaceNet, that is EPO, it actually covers a global patent literature. It is very strong for prior art searching, and it is also widely used for patent examiners. It is widely used by them, so you can make use of them. And similarly, WIPO patent scope, it is useful for international PCT applications. So I already mentioned you about international PCT applications. So this can be made use of it because it helps to understand the global filing trends. So irrespective of specific filing trends, if you just want to know more about global filing trends, you can make use of this tool, because this is the stage where you check whether your idea is genuinely new or it is just having some minor variation or not. So at this stage, making use of these tools is going to be very helpful for you. And for analytical and analytics and strength, you can make use of Derwent and PathSnap, because Derwent Innovation, it actually gives a clean, structured patent data, and it is actually an excellent citation analysis tool, and it is used by many industry and R&D terms. So you can make use of this Derwent at this stage. And PathSnap, it actually they just call it as patent strength indicators, and it is actually a competitor and a portfolio analysis system. It is very useful for this, and it is very useful in many commercial and industry focused insights. So when you're coming in the analytical and strength stage, you can make use of these globally available tools, because these tools are not only for casual use, they are often for some serious patent strategies. They are often useful for valuation, and they are also useful for decision making. So you can make use of these tools at this stage. Yes. And your next is going to be research mapping. Research mapping, in the sense, this stage is particularly important for academicians academicians in the sense dimensions.a, it actually connects, as I said before, it connects grants, publications, and patents, and it also shows how research funding translates into innovations. So at this stage, you can make use of dimensions.a, and as I said before, lens.org, it shows which patents cite academic publication papers. So instead of you sitting and searching it, if you're going to make use of this site, it will show which patents and all cite which application paper. So if you want, you can cite both of them in your work if it is going to be an extension of that. And it also helps the researchers to realize their work has any industrial relevance or not. So many researchers are actually surprised to find that their published papers are already being cited by patents without their knowledge, because these kind of tools are widely used, and this will actually helps to get your work much more cited. It increases your citation, so you can make use of these tools. And at last, filing in India. If you're going to file in India means, then you can make use of IP India and InPass tool. That is after completing all those stages, when you are finally ready to file, you can obviously, these are official platforms, these are not private platforms, these are official platforms. This IP India portal, it is very useful for filing, it is very useful for status tracking, and it is also useful for legal updates. So after filing, with the help of your application number, you can keep on track your status of your patent, and it also gives all kinds of legal updates that is being updated every period of time. This you can just see in this IP India portal. And this InPass portal, it is actually used for advanced search of Indian patents. So if you're going to make a advanced search, in-depth search of some particular patents means, you can make use of this InPass only for Indian patents, not for global patents. And also it is very useful for published and granted documents to study about them. InPass you can use. So no matter how advanced the analytical tools are, actually the filing must be done only through official patent office systems. If you are not going to do so, then obviously it won't reach the next stage. So you can make use of all these tools in the preliminary stage as well as in your upcoming stages, but finally you should file it with a proper move. You should file it with a proper professional with the aid of the professional. If you are going to file it in a proper way in a patent office system means, obviously your patent will get granted. So yes, so thank you for your attention. I hope this session has given you some basics about patents, because since this is the first session, I just want to give you all the ideas about patents, what are the types of patents, what are the right tools that can be used for patenting your work, and what and all can be patented, what and all cannot be patented, what are the stages of patents, because most of us are not aware of what are the stages of patent. So I think I have just given you a wide idea about it. So
Thank you,
I will
ma'am.
be happy to take your questions. Yeah.
Okay, ma'am. Thank you for your informative session. Dear participant, kindly post your question in the chat box. This speaker is very eager to address your question. Kindly post your questions in the chat box.
So I think there are no questions.
Yes, ma'am. Thank you, ma'am.
Yeah.
Good afternoon, everyone. It's my privilege to propose the vote of thanks at the conclusion of FDP on intellectual property rights in academic session 1. Our sincere thanks to Dr. Krishna Kumari ma'am for delivering such an informative and thought-provoking session. We are also grateful to our management for their vision and continued motivation in organizing academic development program like this to help us to strengthen our teaching learning ecosystem. A special words of thanks to all faculty participants for your active engagement. Once again, I thank you all. Thank you, ma'am.
Thank you, sir. Thank you so much for giving me this wonderful opportunity. Thank you, sir. Somebody has asked a question. Ma'am, if it is already published in thesis, can it be applied for patent? No, you can't apply for patent. If it is published in thesis, or if it is even published in paper also, you can't patent it. Your thesis will be available in Shodhganga. So already it is in open source, and your work in your thesis is also would have been published in the journals, so you cannot patent that work. If you are going to show some innovations in it such that has some technical usage and it is more innovative from the already prevailing work, then you can go for patent. If it is already published, means you cannot patent it. You cannot even file it. Yes, sir. I think only one question.
Thank you, ma'am. If any other question, dear participants, kindly post it in the chat box.
Any tool for proofing that our paper does not have any grammatical errors? So this question actually doesn't involve with the patent. There are many tools that shows that many tools that are useful for checking your grammatical errors for papers, right? Many other tools are available. Open source tools are available for language checking, and paid tools are also available for language checking. So you can make use of them. Proofreading tools are available for them. Generally, if they you'll be making use of Grammarly tool and all, a word tool. So these are some general tools, AI tools. So and nowadays the publications are also, they are giving you paid proofing, language editing services. So if you are going to involve in some good publications, means you can just make use of those services, avail those services, because they will make your paper much more fruitful and much more novel. So you can avail those language editing services also. Yes, sir. Anything else?
Any other questions from participant side?
So I'm just posting my official as well as my personal mail ID. So if you have any questions or any queries or for anything else, you can just contact me in this. So yeah, this is going to be my personal mail ID and this is going to be my official one. So I'm ready to answer or collaborate or whatever it is. So you can just contact me in this. Yes, sir.
Thank you, ma'am.
Thank you.
Ma'am, shall you wind up, ma'am?
Sir?
Shall you wind up, ma'am?
Yes, sir, you can.
Yes, thank you. Thank you.
Thank you.
Dear participants, feedback link has been posted in the chat box.